It's January 7th, so can we say Happy New Year still? According to LD, Larry David, you can still say Happy New Year up until January 7th. So happy 2026, everybody.
But by the time it airs, it'll be too late.
I know, but today, so it's okay. I think we're capturing it, okay.
Yeah.
So I hope everybody had good holidays and a nice break.
Yeah, and okay, so our topic for today. I know how much you love liberal legislation.
Well, some actually, I'm actually defending Bill C9. I'm in big favor of that, but that's for another day.
So we've got a new one. It's not exactly new, but this is one of the problems I have is that.
And I have to say, I'm not liking our Minister of Justice federally,
Okay.
Sean Fraser. So a lot of decent things.
Not liking him.
Yeah, no, I mean, I'm always very careful about legislation because so much has damaged what we do. But I think it's very thoughtful to some extent, and I'm not blaming him for what we're about to talk about now because we saw this coming for a while anyways, right?
So there's a new bill that just had its first reading so far on December 9th of 2025. And it hasn't gone to second reading yet. There'll be some adjustments to it, and I'm sure, as it progresses. And it's not, there's a couple of things we're going to talk about. It's an omnibus bill again, so it's got a ton
Bill
of stuff in it.
C16, so we should identify it.
Bill C16. And
it's got its first reading now.
One of the first thing on the bill is creating a new offense that prohibits coercive or controlling conduct towards an intimate partner. And this is not the first time coercive control has been suggested as being put into the criminal code as a specific crime.
Correct.
That's a controlling abusive relationship that doesn't involve physical violence. So they can't be charged under assault or something like that because there's no physical violence. And it's been opposed and it hasn't really gotten very far in the past. We'll see what happens this time, but it's continuing and they keep trying to reformulate it.
So the first, you're like right off the bat, to create a new offense that prohibits engaging in a pattern of coercive or controlling conduct toward an intimate partner. And this exists in the UK. We've talked about this a few times on the podcast. And the elements and what ultimately will be a section if it gets passed with amendments, etc., and ultimately becomes law in Canada, I think will mimic the UK legislation.
One of the concerns that's been expressed that I've seen when this has come up before in the past, because it's been like a number of times over the last few years, feminist groups have actually been concerned that the wording of the legislation could somehow accidentally capture women as the perpetrators, right? So they assume that women are generally always the victims, but they're saying the way you're describing this behavior, like financial control, right? Well, women can financially control men as well by overspending, as opposed to what's generally presented as the man not giving access to finances to the woman in the relationship. It's, there's a gendered bias in the way people talk about coercive control that I think, has been expressed by feminists, that when you just lay it out practically in terms of what it means, that women could find themselves being subject to having committed a crime.
Well, the idea here is that this legislation would apply to any gender.
Right.
So let's frame this a little bit and give just a refresher. And
psychological control is interesting.
So let's frame this by talking about what coercive control is, at least in the UK, Ireland, and other jurisdictions. So generally, it's a pattern of behavior. So unlike incident-based crimes like assault, coercive control requires repeated or continuous course of conduct over time. So a single isolated incident generally will be insufficient for the offense. There has to be a personal connection, obviously, which is a current or former spouse or civil partner, current or former intimate partner, regardless of whether they live together, and it can include family members. And there has to be a serious effect on the victim, or the behavior must have serious effect on the victim legally that is often proven in a number of ways. And whether a reasonable person in the position of the victim would realize that they're being harmed. And I think they're going to have to work with the way they're going to frame this. But what you're talking about, Diana, and I think more germane to our conversation, is the common controlling tactics that certain groups are worried about may capture female complainants. So one of the tactics, which includes non-physical behaviors, isolation. So detaching the victim from sources of support, such as friends and family, monitoring, surveillance, using GPS trackers, checking phone logs, requiring the victim to report their whereabouts at all times, economic abuse, controlling the victim's access to money, bank accounts, or employment. And we can go further to say there can be economic, what I'll call economic terrorism, within a relationship where one partner is recklessly spending money, which essentially puts the other partner at a financial risk or disadvantage, or even deprivation. Deprivation and regulation, dictating that what the victim can wear, where they can go, where they can sleep, etc. Psychological abuse, constant degradation, humiliation. I love this, gaslighting. We've spoken about it. Yeah. And frankly, when we said that men were gaslit in our cases, I think most judges just scoffed at it. Scoffed at it.
Yeah.
Scoffed at it.
But most of what you're describing, these are things that women are well known to do in relationships.
No, but it has been scoffed at. We actually had a judge scoff at us, like gaslighting, like F you, counsel. And our client was gaslit.
Yeah. Provably.
Yeah, or threats of self-harm, suicide to manipulate the victim. So the psychological abuse, and this is not an exhaustive list, but constant degradation. So, belittling the person, humiliating them.
Telling them what to wear. I mean, who's more likely to do that?
Well, sometimes it may be deserving.
Well, you're only big on what color socks.
No, I'm big on certain other things. I mean, well, for men, skinny jeans are out now. Skinny jeans are out.
Yeah.
Okay. But gaslighting is something that, when I looked at, again, the UK legislation, and there's gaslighting in there, and I just thought about how many times we got scoffed at where our clients said they were being gaslit. And, we have seen the issue of self-harm or suicide to manipulate, and that included, frankly, a female doing that to the male to keep him within the relationship and to keep him from breaking up. So absolutely, this cuts both ways.
It does. And that's why the legislation has kind of faltered in the past. That's the right word, faltered?
Yeah, that's fine,
It got to, I think, second reading on one of them, but then it just disappeared. That was a private member's bill. This is a little bit different. Because this bill is coming from the government, the Attorney General. Yeah, it's coming from, the Justice Minister, who's the federal AG, and, this is meaningful legislation that they want to put forward. And, so long as, it's not applied in a gender-biased manner, such that we don't meet with the scoffing again about a male who says that they were gaslit. And we've had cases, again, where we've had lots and lots of messages that establish, frankly, gaslighting. But this must be applied in a gender-neutral manner if it's going to be meaningful. Well, and that leads to the next item on the bill.
But hold on for 1 second. You are firmly of the opinion that it absolutely can be abused, but you're also of the opinion, not being a lawyer, that how on earth are you really going to be able to prove this?
Right. No, that's an important point. Is like, you can't have it be defined so overly broad that a person isn't aware if they're committing a crime. And so the wording of what is going to be defined as what's the threshold to go from being just an asshole or a bitch to being an actual criminal. Because, when you're in a relationship with people, like, you can have your bad moments and all kinds of things can happen, but you need to know what the threshold is, at the point where you should know now that you're committing a crime. And I just don't see how they can define it.
It so happens that I had a discussion with a senior Crown attorney as this legislation was being tabled, And one thing that he had said to me was that he cannot imagine how, with the exception of certain extreme circumstances, with very compelling evidence, including independent, documentary evidence, would they be able to prove such an offense? And that may be the situation. There certainly could be situations where somebody is controlling an individual and there would be evidence of financial control, abusive conduct, and isolation that you could establish. But I would imagine that in the drafting of the section, it's going to have to be fairly detailed about elements, and it's going to take a fair amount of case law to fine-tune this.
And it has to be extreme enough in the description of what becomes a crime to separate out just couples going through a bad phase in their relationship.
Yeah, of course. And there may be other external circumstances to a relationship that would cause one partner in the relationship to take control of certain circumstances because of various issues. So you can imagine if one partner is going through an extremely emotional, psychological time, bout of depression, something else, they're not able to focus, they're not able to, a person who's, well, for example, we had a situation with a person who was bipolar, undiagnosed, massive spending spree, unable to manage their finances. That was now having an impact on the other partner, and the other partner was having to take steps now to limit access to credit cards, bank accounts. And this was actually the female limiting the male's access, and then tracking where he was going,
right?
Because she was terrified what he was doing. Didn't result in charges. That I was involved for some other reason. But it was interesting when I think back on it, there were many steps being taken that were controlling, but weren't coercive in the circumstances because of the life experience of her partner at that time necessitated remedial action. Otherwise, they would have been in bankruptcy and all sorts of issues. Right. Anyways, so I'm just saying, I think it's going to be extremely hard to establish in a trial. I certainly can see police can lay these charges, though. And my worry is about abuse and how this will be then. We already see this literally pleaded in family court cases, on a reckless basis. Like, it's just on so many of these high conflict divorces. So now it's going to permeate into a criminal case where I could see police laying charges with what they think are reasonable grounds, but really when you get to trial, it's not going to be reasonable. But again, it's just one other element that is ripe for abuse.
And we know too that complainants will go into the police and say, "Well, I feel like I'm being coercively controlled." We've already it's not currently a crime, but we've had complainants use that phrase.
Oh yeah.
So if that becomes an actual crime, it's going to be very simple to suddenly have somebody thrown out of the house because they can get charged with something based on that phrase being used.
And I expect this to get eventually, there will be some iterations of the actual draft of the section, but I think it's going to get passed eventually.
Well, they keep trying.
I think it's going to.
So we had a concern with the second element in the opening, 1B, right?
Well, it's not an element; it's another amendment.
There's different sections, right? So this is the criminal code section, and then there's other sections that they address. But anyways, 1B is they provide that in the following circumstances, murder, known as femicide when committed against a female person, is murder in the first degree. And then they give 4 conditions that are the circumstances. That is,
it's not cumulative, so it's any one of the 4 conditions.
Anyone,
so in the following circumstances, murder. Let me take out the section on femicide. So murder is murder in the first degree if the murder is committed against an intimate partner in the context of a pattern of coercive controlling conduct. The murder is committed in the context of sexual violence, already elevated to first degree murder. So I guess they're just doing this for completeness. Murder is committed in the context of human trafficking. Yeah, I can see that. Or murder is motivated by hate. And hate has a very high threshold definition, which is already defined by the case of Keekstra. So that's a very high threshold, but I don't have a difficulty with that either.
The thing is that a murder with any of those conditions doesn't matter about your intent. It is automatically considered murder in the first degree.
If one of these, I'm just covered in shit all over it, but I want to read from various things, so I'm not hiding my large belly. Yeah, so if you satisfy any one of these, then it's elevated from what would be, let's say, a second-degree murder to a first-degree murder.
And so what's the importance of intention?
Well, intent applies to second degree and first degree. First degree is planned and deliberate, right? Second degree is if you intend to kill somebody or inflict serious bodily harm or grievous bodily harm and you're reckless as to whether death ensues or not, that's second degree murder. So one can happen in the heat of the moment where you're in a fight or an argument and you lose your shit and you kill somebody. That's second degree murder because of the way you've intended to kill them or you've inflicted serious harm, which you know is going to kill them.
At the time of the action.
At the time of the action. Or the other one is you're plotting a murder.
Right. So first degree means that you're actually planning it out and plotting it.
Right. So the difference
what they've done
then
is elevated
to so you don't have to have planning and deliberation. If it involves an intimate partner, and any one of these things are satisfied, then it's automatically first degree murder. So it doesn't need to be planned and deliberate. Now this is not a new concept, doing away with planning and deliberation. So the criminal code does define other killings as first-degree murder, setting aside the issue of planning and deliberation. So, what comes to mind is what they call in the United States like a capital murder crime, but we have them in Canada. So if it involves a police officer, a constable, a sheriff, and it's not sheriff in the sense of the U.S. sheriff, sort of a peace officer, a person who's acting in the course of his duties, a warden, guards, a person working in the prison with the permission of the prison authorities. If that is the victim of a murder, it's first-degree murder, regardless of planning and deliberation. If a murder occurs within the context of, let's say, a hijacking, a sexual assault, or a kidnapping, irrespective of a murder being planned and deliberate on the part of any person, murder is first-degree murder in respect of the person when death is caused by that person while committing or attempting to commit an offense under one of the following sections. And they mention hijacking an aircraft, sexual assault, okay? So that's already there.
Included.
Sexual assault with a weapon, threats to a third party or causing bodily harm, already there. Aggravated sexual assault, kidnapping and forcible confinement, or hostage taking. So these sections all elevate a murder to first-degree murder already.
So regardless of the impulsiveness of the actions, it's going to be the intent is there because of the nature of the activity that was engaged in.
Maybe, but, hijacking an aircraft, kidnapping and forcible confinement, or hostage taking are not impulsive. So these are deliberate acts where you are dominating individuals in such a way that if death ensues during the course of that, it's first-degree murder. So, it makes sense to me, and during the course of sexual violence, and I'm not sure exactly what they're going to define more as sexual violence, but it clearly says 271, which is sexual assault. So, if a murder occurs during the course of a sexual assault, it's automatically first already. Right. So I think the only real controversy, yes, they're adding human trafficking, but given the nefariousness of human trafficking, and if you're human trafficking an intimate partner, which they're often victims in some of these human trafficking cases, again, this is a planned and deliberate act of human trafficking.
It's very similar to kidnapping or something like that.
You're exerting massive coercive control over that individual.
And like you mentioned, sexual violence was already included in
it is. I just don't know why they do it this way, but whatever.
So
the only new thing to me is it's within the pattern of conduct of coercive or controlling conduct. Right. Again, I think that threshold is going to have to be extremely high, and they're going to have to be very careful about how they define and set out our Canadian version of coercive or controlling conduct to elevate it to first-degree murder. Because controlling somebody's bank accounts and tracking where they're going, I don't think is sufficient in my mind to elevate it to first-degree murder. And the real impact of this is the penalty. So in first-degree murder, if convicted, as everybody generally would know, they're not parole eligible until 25 years have been served. Right. So generally speaking. So, what is the circumstances of the coercive control that allows this to be elevated to first-degree murder?
So one of my concerns is that to prove coercive control, there are some circumstantial bits of evidence you could get, but primarily coercive control would be proved by, if it is proved, it's going to be proved by the testimony of the victim of the coercive control. But in this case, we're talking about somebody who's dead who can't testify.
Right.
So I'm just like, how in the world are they going to prove coercive control, which often is sort of hidden? How, it seems so unlikely that you'd actually be able to prove beyond a reasonable doubt that somebody was being coercively controlled when they're not there to testify about their experience in the relationship.
Well, I mean, on murder cases now as it is, I mean, the police are going to execute production orders and search warrants to gain access to banking records, financial records, gain access to seize all digital electronic devices, search for messages, internet searches. There's all sorts of independent evidence that they may be able to get through search warrants and production orders to establish that there was a relationship of dominance that would satisfy coercive control. So I don't think this is impossible.
It's not impossible.
So what we're talking about is it should be proof beyond a reasonable doubt, and it has to be a high threshold. And my concern is when you're talking about coercive control, the threshold for all of this has to be fairly high on the section itself alone, especially when it's applied to elevating murder to first-degree murder.
Right. So let's.
Can we talk about the femicide thing for a second?
That's the thing I was going to say.
Because
let's go back.
I don't understand this. And
so we had a discussion about this, and there's like a big dash before and after this phrase, murder, known as femicide when committed against a female person, end dash. So it's like, put brackets around it. It's just a thought, right?
Yeah, but legislation isn't supposed to be that.
Femicide is not recognized as an actual crime in Canada yet.
No, it's not. It's murder.
So this is an introduction of a word that's not officially recognized until now. And, when you look up femicide is not just the murder of a woman. It's the murder of a woman because she's female.
Right.
And so that's an important thing. It's like...
That's an important distinction.
Yeah, because, just because of...
Femicide isn't happening...
murdered and happens to be female doesn't...
You're not just killing your spouse. It's killing a spouse or a partner or a female because they're female.
Because they're female.
It's like a hate-motivated crime.
Correct.
Maybe they're trying to connect that to motivated by hate. So if somebody is like one of those alleged incel cases where they are out to kill women because they are women and they harbor hate, which is at the level of like the Keekstra definition, vilification and detestation of a woman, then that may qualify as first-degree murder. I can understand that.
Right.
I don't understand the way they drafted it because it's oddly placed.
It is.
And we don't have that offense. It's just absolutely not necessary to include that in there. It's unnecessarily confusing and could lead someone who's not a trained expert in law to go, does this mean you can only be first-degree murder if the victim is a female? So it doesn't apply to a male intimate partner?
On first reading, it looks like they're just trying to say it's first-degree murder if you kill a woman. That's the way it comes across when you first read it.
Yeah.
But then when you look at the dashes in there, they're saying, oh, they're just introducing the word femicide. And, but if, that's not the right way to do it.
No, it's very troubling.
If there was going to be a thing called femicide, then it should be defined as a provable situation in which the person was killed primarily for the fact that they're female.
You don't need it. So if it survives scrutiny, that murder is first-degree murder if it's motivated by hate. And hate is, for example, you're saying that the murder was committed because the victim was a female. So it is one of those cases where this is almost like an act of terror, right? It's against females. Mm-hmm. You're going to satisfy that section without calling it femicide. But more importantly, it just doesn't
Well,
belong
they
in
already
here.
have in the murder is motivated by hate.
Right. So it doesn't need to be there. And it, again, can lead the untrained observer to go, what are you saying? And then this impacts same-sex partners. So, you know, two male partners, one murders the other male partner in an intimate relationship, is as much deserving of
The same protections.
as a female partner in a heterosexual relationship, or a female partner in a lesbian relationship.
Right.
So I don't know why the it's there, other than political gain to put in femicide.
I think so. And then also, like, think of the case.
And I have more faith in our
it's-
justice minister than this draft, to be honest.
It is fairly rare, but I mean, we have the case in the U.S. of Eileen Wuornos.
No, we had that idiot, that horrific guy who drove down Young Street.
Right. No. But
Manassian, wasn't that Manassian? With the
Manassian,
van
yeah.
targeting. I mean, that was
that
clearly
was an insult case, yeah.
that's motivated by hate. I mean that's as close to a
Eileen
domestic
Wuornos,
terror act against females as you get.
In the States, Eileen Wuornos went about. She presented herself as a prostitute, and then she was murdering men for the fact that they were men.
Right.
She had a hatred of men.
Yeah.
So what do we call that?
I'd call it first-degree murder. I mean, I'd call it first-degree murder, and you could say it's aggravated by hate, right? So, but
Yeah.
I just, my problem is that we're going to turn the criminal code into the tax code, okay? So if you want to take the most complicated legal statute in any jurisdiction, it's going to be your tax code, okay? Now, I liked tax law when I was in law school. I actually got really high grades in them. But it's a very complex document. It's incredibly thick and complex. Our criminal code is getting thicker and thicker every year. And what was so beautiful about Canadian law, criminal law, was that everything was generally understandable and applied well, and the courts interpreted, and of course you had Court of Appeal and Supreme Court of Canada to help with this. But generally, we didn't go into some of this interesting machinations that they have in the United States, third-degree sex assault. I have no idea what any of this means. You know, I when I'm asked to comment publicly on U.S. law, even though I'm familiar with certain things, I'm very reluctant because I don't understand not only the terminology, the purpose of it. Because to me, sex assault, aggravated use of weapon, I get all that. So I'm concerned that we're going to unduly complicate our criminal law for a political purpose.
Yeah.
Women or intimate partners are
I just keep thinking.
are protected.
I think we only need like half the number of laws that we have in there. I think I really.
No, you may. Well, there's a lot of it that there's a lot of it in there that we don't need. But leaving that aside, you know, intimate partner violence is already an aggravating factor on sentence on a second-degree murder. So if you kill an intimate partner, that's an aggravating factor. The parole ineligibility is going to go up from 10 years regardless. 14 years. We had an appeal case where the murder was of an uncle, but it was the uncle of his wife, okay? And because he was going after his wife, but then accidentally killed the uncle, well, not accidentally, intentionally killed the uncle on a second, he got 20 years parole ineligibility, and that was upheld by the Court of Appeal. And that was because it was within the context of wanting to kill an intimate partner. So just think about that for a second. The ultimate victim was a male who was the uncle of the actual target. It was established that he did intentionally want to kill the uncle. And then because it was within an intimate relationship and it was domestic because it was an uncle and so not a blood relative, but a relative through marriage, parole ineligibility went up to 20 years.
This episode is sponsored by EasyDNS. EasyDNS is a domain name, registrar, and host that has a 30-year track record in the domain and web hosting industry. Whether it be cancel culture, platform attacks, or nefarious actors online, move your domain and web hosting over to EasyDNS, one of the most secure web hosting services, and help support Not on Record in the process. All you have to do is go to easydns.com/notonrecord, or when you sign up at EasyDNS, use the promo code NOTONRECORD at checkout. Thank you, EasyDNS, for your support of Not on Record. And now back to our podcast. Thank you.
A lot of this to me is performative in a sense that I think it's trying to appease people who are concerned about this type of violence. Virtual signaling, you know, however you want to call it. We already have these protections, and simply you can deal with this by the courts upping parole ineligibility. So if it's a second on an intimate partner and it's in circumstances that are particularly abusive, somebody can get even 25 years parole ineligibility. So a second could look like a first anyways. It's just, was it planned and deliberate? So I'm not necessarily against, a situation where you can establish the death of an intimate partner in certain circumstances that do satisfy, coercive, controlling, abusive conduct. But we need to be careful how we define that. And throwing away this dashboard part.
What's the threshold for it?
It's going to have to be. Like I said, the legislation's going to have to be clearly setting out elements and define it, and then it's going to take time to interpret this through the courts. There will be, if there's convictions, there's going to be appeals. It's going to be litigated up the yin-yang to the Supreme Court of Canada. And I hope they take out this section known as femicide when committed against a female person. You can have this in a preamble to the legislation as to when you're presenting it to Parliament, why you're doing this, but it does not belong in the body of this legislation.
We do have cases where women have killed their male partners, and quite often they try to use the battered woman defense or whatever, but not always, and some of them are found guilty despite their claim of battered woman syndrome. So we don't have a name for that. Why name a murder something separate just because of the gender of the victim? And of course, gender is all up in the air now anyway. But
yeah, that's true. No, and when you think of it in that end, any person in an intimate relationship, whatever your gender, doesn't deserve to be murdered. Okay, so I just think this needs to be more carefully defined and set out.
Words are important.
I don't think it's necessary in my respectful opinion, but in any event.
I agree. So then they have an element, there's a bunch of stuff I don't really have an issue with in here. There's some things that cause me more concern. We have different things that catch our attention, but...
Well, C is interesting because they're talking about if somebody commits manslaughter in the circumstances noted above, the court must consider whether imposing a sentence of imprisonment for life on the offender, if the sentence is imposed, and making parole ineligibility. So what they want to do on a manslaughter, if it's in the circumstances that we've already mentioned, you would have parole ineligibility starting at 10 years, up to 25 years.
10 to 25 years.
Making it very similar to a second-degree murder.
Correct. Yeah. That is a significant change, though, to up the minimum sentence.
Well, it's defining manslaughter as a murder, in any event.
It's not a mandatory minimum. It's just... I think they're kind of saying it should be open for them to do that.
Impose life on the offender, and if the sentence is imposed, an adult offender is ineligible for parole for 10 to 25 years. So it would be sentenced like a second-degree murder offense. So I don't even know what the point of calling it manslaughter is. I don't think that's going to survive scrutiny, charter scrutiny.
Well, when you look at the wording, it says the court must consider whether to impose. It's not a mandatory. It's just saying they must think about it. To me, it's like, what's the point? If you're going to make a mandatory minimum, just do it.
No, but what they're saying, the court must consider whether to impose a sentence of imprisonment for life on the offender, and if they do, then the adult offender is ineligible for parole for 10 to 25 years. I'm sorry, that's making manslaughter murder.
It is. But they're just saying they must consider it. They're not saying they must do this.
No, but if you impose 25 years, maybe there's a manslaughter that deserves a 25-year sentence, okay? But then you get parole ineligibility between 10 to 25 years. I think it's up to there's already provision there for a judge to craft a sentence where they indicate what parole ineligibility would be, regardless of whether it's a manslaughter or not. So I'm just, you can do that on other sentences as well. So attempt murder. So I just, C is problematic to me, but D is interesting too.
That's so D is dealing with intention as well, or subjective feelings. Sorry, that in criminal harassment offenses charges, the alleged victim has to have subjectively feared for their safety, in order for the threats or harassment to have reached a level of criminal. There has to be a subjective feeling of fear, because some people would be like, you know what, I could just kill you right now, but you don't believe that they're actually threatening to kill you. You have to subjectively think, realistically think that the threat is legitimate.
The current definition is just fine, okay? No person shall, without lawful authority and knowing that the other person is harassed or reckless as to whether the other person is harassed, engage in conduct referred to in subsection 2 that causes the other person reasonably in all the circumstances to fear for their safety or the safety of anyone known to them. Okay, I think it's pretty clear, and there's great, there's subsections. It's all pretty easy to at least understand and then interpret, and there's good case law on it. So now they want to remove from the criminal harassment offense the requirement to prove that the victim subjectively feared for their safety and replace it with a requirement to prove that the harassing conduct could reasonably be expected to cause the victim to believe that someone's safety is threatened.
Someone's safety. Who's the someone?
Well, you can be criminally harassed already if you fear that somebody in your family or a friend is going to be harmed, right? So if you get repeated communications about harming your spouse, harming your child, harming your uncle, that constitutes criminal harassment, right?
Yeah.
So that's fine. This is a bit amorphous to me. And then when you relieve the proof of some subjective fear on a reasonable basis, maybe I'm wrong.
I just don't see. I don't see what's wrong with the way it's currently written.
I don't at all see a problem with it. To prove that the harassing conduct could reasonably be expected to cause the victim to believe. Like, can you have a victim then testify in a case, say, well, I didn't really feel harassed, but someone might. Like, I don't know.
I
like,
know.
This seems, I don't know. This seems really silly.
Then there's other aspects of the bill.
I don't think this will survive.
Some of them make sense. So, I mean, there's a problem when they do these omnibus bills, though, because they put some stuff in there that's actually potentially really good, but then they mix it in with all this crazy stuff, right? So there's other things to do with, child abuse,
Well, no, look at E for a second. Amend the offense of non-consensual distribution of an intimate image to include visual representation showing an identifiable person depicted as nude, as exposing their sexual organs, or as an engaged in sexual activity, if the depiction is likely to be mistaken for a visual recording of that person. So if you are able to draw either on a computer generated, I guess they're talking about...
Likely to be mistaken. I think they're talking Photoshop kind of thing.
I think they're talking AI generated or Photoshopped. That's what I think, but they better be very clear about this.
Yeah. But, it can't be mistaken for a person if it's just a line drawing.
I don't know if it's a stick person. Allegedly.
And then there's F is amending child sex offenses to include prohibiting persons from inviting children to expose their sexual organs, which is fine. I don't think anybody has a problem with that.
G is problematic, though.
G confused me.
I don't understand the discrimination against bestiality. I mean,
criminalize
talk about virtue signal.
The distribution of visual representations of bestiality. So that's not like necessarily a photograph. It could be a drawing. That could be a line drawing, where, like manga or whatever. Like anybody wants to make a joke, even like a one-frame cartoon, making fun of a politician, pretending that they're f***ing sheep, right? Now all of a sudden that's a crime.
I feel that way every time my taxes go up. I'm the sheep, and the politician's f***ing me hard.
No, this is why we have to be very careful about how they word things and the generalities about it. What do you mean visual representation of bestiality? We're not talking about a real animal necessarily. We're talking about a drawing that could be a joke.
Yeah, I have. Yeah, I mean, I'm not sure how this made it in there, but anyways.
I do understand why they would want to make a new offense in Part H of recruiting a person under 18 to be party to an offense.
No, that's great, because we have, we already have, look, there's many offenses where somebody 18 is used for human trafficking cases, under 18 for murder, all sorts of other criminal offenses. So if the person who recruits them can be convicted as a party, can be convicted of recruiting, sure. I mean, I think that'll enhance penalties and that's fine.
Because it's kind of like for decades, as long as I've been alive, it's kind of known that people try and get young people to commit crimes for them because they have lesser sentences if they get caught.
Yeah, we're seeing a lot of that now. We're seeing a lot of youth being unduly victimized. It just doesn't stop tonight. I'm sorry, hang on. Hi, Ben. I'm just shooting a podcast. You want to say hi to everybody?
Oh my God, I didn't even know I was on the phone with you. I didn't mean to call you.
That's okay. Just say like, share, and subscribe.
Like, share, and subscribe. My father's the best lawyer in Canada.
Okay, you're occupying a lot of my podcast time. Bye. Can we just jump to the I, which is concerning to me?
Well, it's except for that it's already happening anyway.
No, I know, but this is codifying this, and please just talk about it.
So, allows that victims of certain types of offenses, such as in the commission of which violence was used, threatened, or attempted against an intimate partner, that they're automatically going to be entitled to testimonial aids. And so that generally means that they don't have to show up in a courtroom. They can go to a victim witness.
Well, what's testimonial aids? Testimonial aids are a number of things. One, these are things that will make it easier for a person, we're going to call them a complainant, to testify in court. So we don't call them victims until there's a decision at the end of the day that the client is guilty, right? So the complainant is entitled to a number of testimonial aids. A support person in the courtroom, a support dog, okay, or goldfish, the use of a screen so that they are unable to see the accused, or testifying through CCTV, which is now testifying in another room in the courthouse, and the lawyer gets to cross-examine through a Samsung or Sony TV.
Right.
Or if it's not a very wealthy courtroom, it could be a Toshiba.
Although I do find that...
Although I like Toshibas.
I do find that you get a better view of their expressions and their testimony. You can hear it better sometimes.
Yeah, except
CCTV.
It's a nightmare when you got to present documents. And for those of us who still... Like, even if you want to... You can't even screen share when you're doing CCTV, right? Yeah. So if you're doing it through Zoom, then you can screen share. So please look at this, please look at that. But then you get like a small picture of the person.
And you can see the document on the big part of the screen, but you only have a small view of their reaction to the document.
Right. Yeah. And so it becomes much more cumbersome, and you lose to some extent. We haven't had it happen most, because what we do is we put together a package, have it brought into the complainant just before cross-examination. But sometimes they're thumbing through it to make sure
they're previewing everything.
So it loses some of that spontaneity. But I do believe it really erodes, this is my opinion, the right to face your accuser.
Right. And so typically...
Because we don't seem to care about that anymore in cases involving sexual assault or domestic violence. We don't.
And they call it like victim services. They assume that they're victims. But so like you mentioned, it's a problem when you're trying to present documents and direct them to things and so on. But the seriousness of the situation is what are the reasons why it's better to have somebody in court? Put it that way. What are the reasons that it's better to have a witness testify in the courtroom?
Well, for one, I think it's a basic tenet of our legal system. You get to face the accuser. So I think it's much easier to tell a lie to a TV screen or a camera than it is when 20 feet away is the person you're lying about. Mm-hmm. So that's just a basic psychological issue, in my opinion. Mm-hmm. Number two, your accessibility to the witness is much better when they are in the courtroom, because cross-examination is not just about the questions you're asking. It's about the physicality, the emotional, the drama of the courtroom will have an impact on a witness. Often will encourage them to tell the truth, in my opinion, not discourage them from telling the truth.
Right.
So when I'm in a courtroom, I generally will stand behind the podium, but sometimes I'll walk away and be more in direct line sight with the person, or as I'm approaching them to hand them a document, I may stand beside them and ask them questions. I give them some space and I'm not yelling at them, but there is an element of contact and physicality that impresses upon a witness the seriousness of what you're, and I'm calling them a witness because they are a fucking witness, okay? That impresses upon them the seriousness of the moment.
Yeah.
I don't think it's the same when you're in a separate room. It has not really impacted the value of our cross-examination when we've done it countless times through CCTV. However, it takes away from the drama of a courtroom, the right to face your accuser, and there is a certain element. I mean, I've had this in cases where I'm making direct eye contact with the person 5 feet in front of me, and they know I know they're lying. You can just see when they're caught.
Yeah.
And then it all comes down.
Yeah.
And I think we're losing this humanistic aspect to the trial.
Yeah. And they're not supposed to acquire testimonial aids unless there is sufficient evidence that they would not be able to give their best evidence without them.
Yeah, and I'm losing some of the cases now that are being decided on. I mean, the threshold is
so low.
Is being so watered down that it's being ordered almost.
Can I just skip?
It's very rarely denied, and I'm very concerned about this. I'm concerned about it because I'm really concerned about it because in cases that we've dealt with so many high conflict divorce cases and vicious complainants who have just done such horrible things in the family court process and used the criminal for leverage and to vilify and literally destroy their former spouse. And the idea that they can be sitting behind a camera in a room with a support worker and nobody else and being coddled that way and shielded from having to face the person they're accusing, in my respectful submission, is wrong. In certain circumstances where you're able to establish something unique about the complaint. So if the complainant has a particular disorder, where even a medical condition that will be exacerbated, or you will cause a flare-up because of the stress and anxiety of a trial and of a cross-examination, and you have expert evidence on that, yeah, I get that.
Yeah.
Okay? So if somebody suffers from psychologically, and they're diagnosed with a panic disorder, they can freeze. I know we're running long on this. I get it. But when you legislate it this way, maybe it's meaningless, maybe it's not. I think this sends a very strong signal that it will be a fait accompli, that everybody will get CCTV. I don't think it's great.
I think, in terms of the things being proposed, one of my bigger concerns is that is part L and M, where they're
Can I just go to J for a second? It doesn't have to deal with sexual assault, but I did a piece on mandatory minimums, and our bloodthirsty country thinks that we're letting fucking pedophiles off by striking down mandatory minimum sentences, and we're not, because the sentences are high. But J is permit courts to order that an offender serve a period of imprisonment below a mandatory minimum term of imprisonment, but only if the mandatory minimum term of imprisonment would amount to cruel and unusual punishment for that particular offender. Okay? So this is where I applaud...
As far as I'm concerned, all they're saying is get rid of mandatory minimums.
This is where I applaud the Liberal government. So this is where I have, where Sean Fraser has me applauding, although this is a convoluted, I think, different... I don't know, again, how you'll go through this, but I don't believe in mandatory...
Why not just remove the mandatory minimums?
Well, that's right. So I think what they're trying, it's a political thing where it's going to say, okay, we're going to have mandatory minimums, but a judge is allowed to go under it if you can establish that it would be cruel and unusual, which is basically akin to what the application would make to strike it down. It's a bit of a mess, I think, but I think the sentiment of our Justice Minister and those who work with him, who's drafting this, is they recognize that mandatory minimums can be cruel and cause unusual punishment in certain circumstances.
They're consistently being struck down.
And that's why sentences have to be crafted by the judges in accordance with the sentence. Anyways, I just had to mention that because this is what happens when we have to play politics with criminal legislation. Yeah. And actually the government gives a shit about the sentencing phase.
So I'm very concerned with L and M. They're kind of connected to each other. But this is dealing with, there was a case called Jordan, which set time limits on how long a prosecution can take before it's...
We're going to end at these because what time are we at?
52
Okay, this is important stuff. I'm sorry, but it's important
It
stuff,
is.
and I hope everybody who's watching is interested in
So
this. But
there's a seminal case called Jordan, which set limits on how long the Crown can take to complete a prosecution.
or the
of a case.
court has to complete the prosecution.
The court has to, yeah.
Yeah. So
And-
18 months in the Ontario Court of Justice, 30 months if you go to the Superior Court.
And in sexual assault cases, there's now increased burdensome pretrial motions that are required. And, since Bill C16, which we've talked about a lot, the defense has to bring applications. Now, since Kinnamore,
Right.
recently, the Crown has to bring applications. So they've put in here that they want to create a new part in respect of unreasonable delay that requires a court to consider specific factors in relation to case complexity, directs the court to exclude time periods in respect to specific applications, that requires that a stay of proceedings be ordered only if a court is taking into account a list of factors that no other remedy would be appropriate and just. So they're trying to make it, because when you do these applications, you have to subtract reasonable delay, like unexpected acts of God, or COVID, defense delay, things like that. So it appears that they're trying to say that you can't count pretrial applications as part of the delay.
I don't know, maybe. So there is also a lawsuit commenced. I think it's Catherine Marshall and somebody else who brought the lawsuit on behalf of a number of complainants in sex assault cases that were stayed for delay, that the government had a responsibility to ensure that the cases were tried on the merits. This is the government's response, in my opinion, because this... And of course, there was also murder cases that had been stayed, but those were in circumstances that were highly unusual that they were stayed. But they're now creating a statutory provision, and they're going to have to be very careful how they define this. What specific factors of complexity are they talking about?
Right.
And then direct courts to exclude time periods in respect of specific applications. What the does that mean? It's not the accused's fault that the government decided to create unduly cumbersome applications.
Right. They've made it one of the most complex. Sexual assault is one of the most complicated areas of law now, aside from murder.
Remember that case that we reviewed by that judge? Was it in Saskatchewan?
It was a great statement.
It was an excellent judgment where the judge went into a treaty on how complex sexual assault cases are now. Mm-hmm. And there are some lawyers who say, like, I don't even want to fucking do it anymore because of, just these applications and all the machinations you have to go through in the arguments. I think they're talking specifically about what you say, which is these pretrial applications.
Yeah.
And that's not our fault. And this is an access to justice issue.
So what we file our applications 3 months in advance. So what? Yeah. So now we have to take off 3 months because we filed it at a certain time. Like,
I don't. Who knows?
How would you even define that?
I have no. It would be better if just somehow there was a reference done to the Supreme Court of Canada. You can direct a reference to the Supreme Court of Canada to reconsider Jordan.
Yeah.
And I think the time is ripe for that. Don't do it this way. Don't do it, because this is now going to create more constitutional litigation.
Yeah, and in the final one, which I see as
this is literally going to result in the reconsideration of Jordan by the Supreme Court of Canada.
And you're right to a speedy trial, like not speedy, like super fast.
A trial within a reasonable period of time.
Within a reasonable period of time, and that's a constitutional right that's now being challenged. So
now look at M.
But M, yeah,
we're going to end on this one, and I want everybody to carefully listen to, especially those who followed our podcast and remember what we talk about Section 276 and 278 applications, and that's other sexual history evidence or activity evidence.
Or evidence in your possession.
Read it slowly.
And this one is my what the paragraph, to tell you the truth. Streamline, this is the proposal, to streamline and strengthen the procedural rules in sexual offense trials that govern when evidence of a complainant's past sexual activity can be adduced, and when certain private records, including therapeutic records, can be produced or adduced. And then they go into another one. So what does that actually mean? Because I think it's pretty strong. With the Bill C-51 changes, they've now got standing, like, how much stronger What do they mean? You can't.
I
it's like-
am terrified
of what that means.
of what this streamline and strengthen the procedural rules in sexual offense trials that govern when evidence
Which
of a
rules?
complainant's past sexual activity can be adduced. And it's not past sexual activity necessary. It's defined as other sexual activity in the legislation. Okay?
Right.
So 276 was amended, other sexual activity can
Anything
be
of a
adduced.
sexual
and when
nature.
certain private records, including therapeutic records, can be produced or adduced. Now, frankly, we never ask for therapeutic records, but on occasion it becomes relevant. But the basis on which to get access to therapeutic records and then have them admissible is already stringent enough.
It is.
Are they now going to legislate that no past sexual history evidence is relevant?
How do you make it more stringent?
Like,
than
what the
it already
does
is?
this mean?
That's the thing. Is like, just strengthen. Strengthen how? Strengthen which? Strengthen. Change what words? You know, like it's already. It was already challenged constitutionally, and it came close to being overbroad in what they were doing. But the Supreme Court narrowed down the application and the standing of the complainant. How in the
That's
world?
originally on C. Boyer in 276, and JJ as
then
well
JJ.
was also a close decision.
It was close.
This is going, and if this is legislated somehow, it's going to lead to more constitutional applications and maybe, God willing, the overturning of these provisions then, right? And this is going to cause countless delay and unnecessary constitutional
It
applications.
hasn't been that long since JJ was validated by Supreme Court as being okay under certain contained, applications of the standing of the complainant and all this other stuff to make it constitutional.
Well, JJ said
it wasn't that long ago, and now they want to strengthen it even more. It seems insane to me.
Yeah, this can be extremely problematic, and everybody should be really concerned because
Very
I'm just going to give you one example that we're dealing with where we have a case where there's basically a 24-year period of time of sexual assault
Alleged.
This isn't the first time we've dealt with this, but it's very hard to tell whether it's a number of incidents or the entire time span. It's very hard to tell. We won't really know until the complainant testifies because it's not clear in the statement, but it looks to me like the entire marriage was one giant
Pretty
sex
much
assault.
every other night.
But the Crown is objecting to our client's affidavit, which essentially will be his evidence, and we weren't even asking permission because in our dumb brains, we're going like, well, this is she's alleging that all their sex was non-consensual.
Their entire relationship was one big sexual assault.
Right. So he has to testify as to the narrative and the unfolding of their
Over 20
relationship.
years.
And his defense of how they had communicated consent and sexual activity was consensual. The Crown's objecting to large portions or to him testifying about his own defense.
Right.
On it. So you can imagine now if some legislation comes in and says past sexual history cannot be admitted by an accused unless in these few exceptional circumstances. Okay? Then what the f*** are we supposed to do with a 24-year indictment?
Yeah, they have to put in there cannot be adduced by the defense or the Crown. It's like
This is scary. This is where
It
I
is.
am critical of who's drafting this. I mean,
I am.
I think our current federal AG is trying, but they're wading into areas that's going to be a problem. It's definitely better under this regime than it was under Trudeau. Trudeau created a mess with his justice minister who then resigned because they got into a fight or whatever the it was. But they really created a criminal law mess.
Yeah.
I think our current AG is trying to avoid a criminal law mess, but they're going to step into it here. And these two provisions are very scary. So we've ran long, so I'm sorry about that.
That's the summary of what's on the table. And the interesting thing is, even if this ends up not going all the way through,
Some of it
there's a
won't.
lot of repeat in there. Like there's things that just keep coming back, like coercive control. This is the fourth time I've seen coercive control.
I think it's going to get through. Anyways, we'd be interested to hear about your comments and your questions. Please, continue to email us or make comments during when this drops. And Pillow Talk.
Don't forget to like, comment, subscribe, and share.
Max, what number are we up to now of episodes?
This will be 195.
So we're almost at 200 episodes. We're almost at 5 years, eh?
Yeah, I think so. I think we started in 2021, right?
Yeah. during the pandemic. Wow. So thank you all for your continued viewership, your support. Please share, subscribe, like. We're so happy to continue this, and thank
And
you
we
for
do read the
listening to
comments.
us. We absolutely do. So good night and take care, everybody.